I'm handing over now to Ian Harden for the next session.
Thank you, Jacques. Our second speaker this afternoon is Joana Mendes, who's just going to the lectern. Joana Mendes is from the University of Amsterdam, and she's going to be speaking under the fascinating title of Where the Courts Do Not Enter, Discretion and Good Administration. Joana.
Thank you very much. It's a pleasure to be here today. Fascinating and possibly maybe too daring. You'll let me know then in the discussion. My purpose here today is to draw attention to what the specific contribution of the Ombudsman could be in reviewing administrative discretion. And what triggered me to look into this is that in in legal scholars, usually when the topic of discretion comes up, the perspective is always, or the control of discretion comes up, the perspective is always the judicial review of discretion, maybe also political control of discretion, but as far as I'm aware, hardly ever what can the Ombudsman do when reviewing administrative discretion. And my purpose is to explore the possible comparative advantages. I should say, by way of disclaimer, that this is still very much work in progress. At times, I may be a bit too abstract, but I hope to be sufficiently clear. So I will start with some preliminary remarks regarding why discretion and why the Ombudsman. I will then revisit briefly what the courts have done when reviewing administrative discretion. And I will pause for a while on the meaning of the duty of care. This will become hopefully clearer in a while. To finally focus on what could be, instead of why, maybe there should be a what there, what could be the distinctive contribution of the European Ombudsman in structuring administrative discretion. So why discretion and why the Ombudsman? At first sight, both the courts and the Ombudsman are bound by the same broad limits when reviewing discretion. The standard of review, in broad general terms, is the same. When faced with wide discretion of an institution, their control should be limited to checking whether the procedural rules have been complied with, to examining whether there is a manifest error of assessment, to assessing whether the institution has misused its powers, or whether it exceeded the bounds of its discretion. So neither the courts nor the Ombudsman should review the merits beyond compliance with general rules of law and general principles of law. Yet, within these broad limits, the very nature of discretion would indicate that the Ombudsman would be particularly well placed to review, to structure the exercise of discretion. Why? Discretion lives within the boundaries of law, obviously. The exercise of discretion needs to be bound and needs to be limited by law, needs to be exercised via procedures defined in law and at least framed by general principles of law. But discretion also strays clearly beyond legality. Discretion is about policy choices that may be determined more by political determinations rather than legal provisions. Discretion is about making expert judgments or relies in expert judgments on the basis of which complex technical assessments are made. Discretion depends on bureaucratic motivations. It depends also perhaps on the moral and the ideological preferences of the officials or of those involved in decision-making. So the exercise of discretion should be structured in a way that respects this complex nature of discretion, that does not curtail the space for this mixture of policy, expert, bureaucracy, which is of crucial importance. And it is for this reason that, prima facie at least, the Ombudsman would be particularly well placed to structure discretion in a way that is not limited to considerations of legality. Because of the mandate, obviously, maladministration, the control of maladministration extending beyond legality, because of the tools and means of action which enable broader inquiries than just the verification of whether the law was complied with, or in determining what the rights of the complainants are in an instance and whether they were breached or not. Because of the specific institutional position of the Ombudsman, which is quite different from that of the courts, given its constitutive links to the Parliament that were mentioned already this morning, the possibility to report directly to the Parliament on instances of maladministration. But these are only prima facie reasons, abstract reasons, that in abstract support the claim that there may be something specific about what the Ombudsman can do. What then is that something specific? And I will try to come as close as possible to an answer, but I'm afraid that the path may be still a little bit too long until I get there. I will start by revisiting briefly. So if I'm looking for the specificity, it's important also to revisit briefly what the courts have done. The standard of judicial review of discretion, is the one that I mentioned earlier. Control of procedural rules, control of for manifest error of assessment, misuse of powers, respect for the bounds of discretion. And the courts have used this standard in different ways. I will just briefly highlight one tendency. Arguably, still to be determined, but arguably there is a tendency for more stringent judicial review. The courts certainly have not shied away, at least in certain areas, from reviewing in-depth technical assessments in a detailed way. And Tetra Laval has, in a sense, set the motto for a broader trend. The standard of review is the one that I mentioned before, but the courts have clearly stated that the courts must not refrain from reviewing the Commission's interpretation of information of an economic nature. The community courts must establish whether the evidence relied is factually accurate, reliable, and consistent, whether that evidence contains all the information which must be taken into account in order to assess a complex situation, and is capable of substantiating the conclusions drawn from it. So quite a stringent approach to judicial review. And this is a line of reasoning that has been reiterated. This judgment is from 2005. It has been reiterated in other areas, in areas where the complexity of the assessments were not exclusively or at all related to issues of economic nature, economic and financial sanctions against individuals, for example, but also in cases of risk regulation. So the courts, my main point is the courts have been willing, at least this doesn't exhaust everything that the courts have done, obviously, but it shows the willingness to go to perform a searching review of the factual basis upon which the Commission exercises discretion. And this hands-on approach to judicial review of complex technical assessments is also confirmed by cases where the General Court has reviewed compliance with the principle of care, with the duty of careful and impartial examination. And here I'll just, again, be quite brief, not paying sufficient heed to the complexity of the case law, but in any event, the duty of care, the duty of careful and impartial examination, needs to be observed by the administration as part of a proper administrative conduct. It is an essential tool to exercise discretion, to revise the factual basis of discretionary decisions. The court has explicitly said, this is one example, the duty of the Commission to gather in a diligent manner the factual assessments. It refers to factual assessments necessary for the exercise of its broad discretion. The court has also stated that compliance with the duty of care is all the more important in areas of broad discretion. It is important in view of the limited review of the merits that the courts may perform. But the duty of care has also been a way, it has had an important effect. It has allowed the courts also to apply a more stringent standard of review while keeping within the same, using the same formula of limited judicial review that I mentioned before. Bearing these two lines of case law in mind, the searching review that the court has done of the factual basis of the complex assessments, and this line of cases regarding the compliance with the duty of careful examination, one could legitimately doubt whether is there anything left. What is there to be done that hasn't been done yet? What is the space where the courts do not enter? And more specifically, what could be this distinctive contribution of the Ombudsman here? At this point, I would suggest pausing a few minutes on what I have said and what this meaning of care, what the duty of care actually means. So what I've said so far is that the court is willing to perform a quite hands-on approach to judicial review when endorsing a more stringent review, when ensuring compliance with the duty of care. But the court always explicitly refers, both strands of case law, explicitly refer to the assessments of facts. The standard of review defined in Tetra Laval applies to the Commission's interpretation of information of economic nature, whether it's factually reliable, consistent, etc. Similarly, in applying the duty of care, the General Court has also referred explicitly to gathering the factual assessment, the factual elements necessary for the exercise of discretion. And what I would like to highlight now is that this focus on factual information and factual assessments hides one important feature, in my view. It hides the fact that the processes of collecting information are intrinsically linked to the public interests that need to be pursued in each instance. Hides the specific purpose behind this collection of information and these technical assessments. And the point that I'm trying to make here is that the assessment of facts and the appraisal of public interests cannot be treated separately, that they're closely interlinked. The EU legislation defines in abstract in each area which are the public interests that need to be pursued: environment, public health, competitiveness, etc. But these abstract provisions only acquire meaning before a given situation, only when confronted with specific facts. Is it clear or not so clear, but does it become clear what it means in a specific situation to protect the environment? And the type of, for example, and the type of protection that these and other interests would require will also only become concrete while assessing the factual information. And while this may seem obvious, and it is obvious to a great extent, I think it is worth pointing to consequences that follow from this. First, the duty of careful and impartial examination of facts, in my view, is not dissociable from the way to act in a way that ensures the protection of the public interests that need to be protected in each instance. So basically what I'm saying is that the normative duty of care is broader than what the courts have stated so far. And second, importantly as well, the processes and structures of collecting information and of conducting complex technical assessments shape directly the balancing of interests that is done in each instance. So what I would like to suggest is that this broader meaning of care lies precisely in this link between factual assessments, factual collection of information, and the pursuance of public interests. It would be care in this sense, in this link, that should structure the exercise of administrative discretion. But in stressing this link, I may also come dangerously close to the limit that neither the courts nor the Ombudsman should transgress, if I can use that word, should cross when controlling the exercise of discretion. I'm entering the realm of policy choices and the assessment of policy choices. The courts have on occasion mentioned a broader meaning of care that could resonate somewhat what I'm saying here. The courts have mentioned, while claiming that the duty of care does not have a protective, in certain areas does not have a protective dimension to the litigants, that the duty of care needs to be complied with in the interests of sound administration of the fundamental rules of the treaty. Only that in the cases where the court has said the duty of care does not have a protective dimension to the plaintiffs, but it has an objective meaning in the sense of pursuing the sound administration of the fundamental rules of the treaty, what this actually means has become rather vague, and it remains an elusive idea, at least I couldn't find in a court's case law what would this be? What would be the duty to comply with the compliance with the duty of care in the interests of sound administration of the rules of the treaty? And what I argue is that the reason why this remains vague is because the courts would be faced, is precisely because of the institutional capacity of courts, and the fact that they're faced with claims that they need to adjudicate in terms of legality and non-legality. So, to sum up, I'm insisting on a duty of care, abstracting from individual protection, from the individual examination of the claims put by each litigant by each party before the commission before. And what I'm saying is that in this objective meaning of a duty of care linked to the pursuance of public interests, this is where complex technical assessments and policy choices meet. Why could the Ombudsman, rather than the court, flesh out this objective meaning of the duty of care? Because of the reasons that I stated before, because the mandate of the Ombudsman goes clearly beyond legality, because of the institutional position of the Ombudsman, because of the tools that the Ombudsman has to control the soundness of administrative processes. I would claim that the EU Ombudsman is in an institutional distinct position to control and structure discretion in a way that explicitly brings out this link between pursuing public interests and making accurate factual assessments. But both the General Court, obviously, and the Ombudsman may investigate the factual basis of decisions. I'm not saying that the General Court does not do that or wouldn't be able to do it, certainly not. But what I'm saying is that the Ombudsman can go deeper in scrutinizing the objectivity and pluralism in balancing public interests by scrutinizing the very information structures that ground then the way the Commission exercises discretion. And these are the structures, expert groups, impact assessments, public consultations, these are the structures that decisively influence the balancing of interests that then end up shaping, I'm claiming, the final decision that is made. And here is where I think that the courts do not go and should not go. And I'm thinking of issues such as the composition of expert groups that has been already mentioned before, but also of the desirability of asking for opinions that are not legally required but could enhance the protection of certain public interests, or of the desirability of holding meetings that are not legally required but could act in a way to protect the public interest, or could ensure the proper consideration of competing interests that clash with the prevailing interests in one instance. So I'm talking about practices that are not mandated by law, but that would ensure the plurality of public interests in administrative decisions that decision makers should consider as part of their structures of processes of decision making. And if I still have some time, I would like to just briefly talk about one example in the field of biofuels, one example that I think illustrates what I'm trying to say quite well. There was a complaint before the European Ombudsman. The complainant complained that European biofuels technology platform was exclusively composed by industry representatives, and that is meant a bias in the decisions of the Commission. Very briefly, the Ombudsman was satisfied with the Commission's explanation regarding the composition of the expert groups, but still considered that the Commission should explain in what way those decisions, those opinions, were not biased. It should explain through which mechanisms the Commission would ensure the objectivity of the advice that it was being given. And this for one important reason, and this is where I think gives some anchorage to the work of the Ombudsman in this case, because the directive at stake said that as much as competitiveness of the industry was important, there needed to be impact assessments of economic, social, and environmental implications. So this meant, in the view of the Ombudsman, that the Commission could not justify objectivity of the decisions purely on the argument which the Commission put forward, that these were technologically neutral opinions that it was receiving, because there were actually complex assessments of competing interests that need to be taken into account by the Commission. So by recalling the general interests that needed to be protected in each instance, the Ombudsman made this link between the assessments and the structures, rather, that were in place to make these assessments and the public interests mandated by the EU legislation that needed to be protected in that instance. And just to conclude, very quickly, why the Ombudsman again? Shaping practices, as I said, that would ensure the plurality of interests at stake. In my view, the fact that this can be done via friendly resolution mechanisms rather than purely adjudication framed in terms of legality or illegality is crucial, because it's not the judicial procedures are not well suited to inquire into these deeper structures and processes of decision making. Thank you very much.
Thank you. Thank you very much for an excellent presentation. You started out by saying that it was going to be at a high level of abstraction. There was some highly abstract material, but you also operated at a very concrete level and bridged the two very nicely. So thank you for that presentation. I'll throw it open now for questions or comments from who would like to start.
That work? Yeah, I just give you another example where there was a complaint against us to the Ombudsman, and the Ombudsman examined our complaints procedure and said the procedure itself was fine, but that what we told complainants in public about the procedure was insufficient. So that was an interesting example of what you're talking about being able to go further, where we didn't realize, we knew what we did. And so it was quite a helpful comment by the Ombudsman to say, make it plainer, and we still have to do that, don't tell the Ombudsman, but we're working on it, but make it plainer to complainants what you actually do, so that they can benefit better from the procedure. So I think this idea of going into the process and seeing what you can bring out to make it more effective, so that the result is fair, is a very, very intriguing one.
Takis Drilimas first, and then Jacques Seller.
Thank you, Joana. I found this fascinating, very interesting. and I certainly have not thought anywhere as much as you have about it. If I understood you correctly, but maybe I didn't, if I understood you correctly, that the Ombudsman can offer judicial review plus something else. In case of technical assessments, I think I have difficulty with that. I can't see why that should be the case. I think I would have difficulty with that as a citizen, as someone who is affected by a decision. I think my first port of call would remain the court, not the Ombudsman, because of the type of remedy that I can get. So when it comes to technical economic assessments, competition law, state aid, many areas, in the case law, we don't need to, risk regulation, we don't need to rehearse the various areas. I think you are taking the limitations of what the court can do for granted, and you are looking to an alternative institution to offer you something more. And I'm not sure if that is what you're saying, I'm not sure that I share that underlying premise.
I take your point, and I certainly need, but my point is not that the courts or the Ombudsman should be, that the Ombudsman should be doing more than what the courts are doing when reviewing technical assessments. So my premise, at least in the presentation, is that the courts already go quite far in examining the technical assessments. My point is that what the Ombudsman can do is different, and different in the sense, in I think, an important way, which is, so what I think is the courts, you're certainly right regarding remedies, but there is an administrative process behind the decision-making that the courts need to translate into a binary code of adjudication. So highlighting the politics, the small politics, if you want, behind the technical assessments may not be, or the courts may not be as well equipped to do it as the Ombudsman, in the sense of going deeper into the structures of decision-making. But you may be...
Why do you think the courts cannot do it? What is it that prevents a court from doing that? It seems to me that they could do it if they wanted.
Okay.
Secondly, that the process of adjudication is capable of catering for that. So I can't see any systemic limitations in the process of adjudication that would make the courts inherently incapable of going the extra step. Incidentally, I'm not necessarily going to take issue with whether the courts go far enough. I mean, you are assuming that they are going far enough in making technical assessments.
Well, that they may, that they show the willingness to do that, but not, certainly what I've said doesn't cover the whole spectrum of what a court does when reviewing judicial discretion. But you're certainly right, I need to flesh out more what the courts can do or cannot do. My thought underlying my presentation is more that the courts would be more prone to criticisms of going too far into policy-making processes than the European Ombudsman would be. And that has to do with the way of acting of the Ombudsman, but also of the institutional position of the Ombudsman, which is not to ensure compliance with the law. It's to ensure that there is good administration and eventually to report to the Parliament. So this institutional position, in my argument, matters. But to work further on that, certainly.
Jack, with your permission, I'm going to give the floor to Jack Rosas, should be the last, because he may wish to comment on this issue.
Well, I probably can't resist the temptation to say something when we had this interesting exchange. Probably I should do like Jacob Söderman to say that I shouldn't say something but still say something. I think maybe this is dull, but I think you're both right. I mean, I think it's obvious that the Ombudsman can and should do things that the courts cannot. And I'm not primarily thinking about maybe competition law and state aid, which is in any way a kind of a particular subject also from the point of view of the courts, because the General Court has full jurisdiction, as you know, also on the amount of fines and so on. So it's not just annulling or not, but there are some further. What the courts certainly normally cannot do, not at least very openly, is to give advice somehow. I mean, how should things be improved, and also even taking that something is legal, as has already been said before. Obviously, the ombudsman can say, well, it might be legal what you have been doing, but why don't you still do a little bit differently, because that would improve things and improve confidence of the citizens and so on. On the other hand, I think Takis is right that maybe, I mean, I'm sure it was not your intention, but maybe when you spoke about judicial review and you talked about Tetra Laval, which is dear to my heart because I was a judge rapporteur, but you stressed in that context that we sort of look into whether the facts somehow are right and whether there was a proper examination of the facts and so on. But as I'm sure you know, judicial review in many areas may go much further. I mean, we look into procedures. Has there been a fair hearing? Has someone been heard or not? Look at the terrorist and other sanctions cases where many decisions have been annulled, in that case by the Council of Ministers, because the person has not been heard and so on. We look into institutional questions if the law says something about how institutions should be constructed. So I mentioned already before the lunch break the question of independence. Sometimes European law requires that someone is independent from the rest of the administration, and this also concerns national officers or national units, as I said. So these kind of institutional questions. And we also sometimes have to look at whether something or someone corresponds to the legal criteria given. So to take the sanctions cases as one example, you know, when businessmen very often from other countries are hit by EU sanctions, and then they come to first the General Court and then to us, where we give, for obvious reasons, very broad discretion to the Council of Ministers, is selecting the criteria. I mean, is it enough if you are a company in Russia which is owned 51% by the state? Is that hit by the sanctions? Or what is the criteria for being hit? That is a political question rather than legal one. But then when you have the criteria, does someone fulfill those criteria? That's full judicial review. And in fact, we have been much criticized by many people who are probably not present in this room for going far too far in judicial review in this area. But we have insisted in principle on full judicial review.
Thank you. Well, I have listened with great pleasure to your bright analysis of this issue, and I was reflecting on the title of your contribution when it comes into print, and I thought maybe the title might be Handling the Hot Potatoes. In the sense that if we look at courts in Europe and the European Court as well, you can see that judges are, well, very careful with the issues you are touching upon. So they have different approaches, but the approach is they don't handle the real hot potato. And now you are pleading that the Ombudsman should really take the hot potato and give some observations which in the perspective of maladministration, but I would say more good administration and being fair. For instance, in the biofuel case, being fair towards the public. And I think your idea needs some support in the sense that I'm supportive to your idea, and I think that the Ombudsman should be invited to handle hot potatoes in a diligent way. Thank you.
Yes, I'm happy to see that Joana is following a big European tradition of big Portuguese thinkers emigrating to the Netherlands. But it's for another reason. I'm finding you more easy to understand than Spinoza, but that's another story, probably because I'm a lawyer, not a philosopher. On this discussion we just had, would simply also recall what Ian said earlier. The court, whatever they do, will either annul or allocate damages. The European Ombudsman cannot allocate damages, but he or she has already said sometimes, well, you might give a compensation, and institutions are not happy in that. But especially here, you're not saying that the decision is void. You say it could be done in a better way. Now, that's just adding to the discussion we just had. I wanted to make 3 remarks. One is about duty of care. The way I read the jurisprudence of the courts is that the duty of care does not simply encompass public interest. On the contrary, it says that in the duty of care is included the fact that the institution has to take care of the interests of the applicant. And that's very interesting. And here I don't see a difference with the European Ombudsman. I don't think it's what you wanted to say. Then something came to my mind, which is probably you could get further in your reasoning. If you think about the case law on motivation, I'm thinking obviously of Halens, where the court said not only as classically in that time motivation, reason giving serves for future judicial review, but serves also for the individual to decide whether he or she wants to apply for a judicial review. And you're adding one further step, but why not? Which can also be in motivation. It's giving a better idea of the balance of interests. And the last one, but I think it's the most important because I know your interest. Maybe what you're trying to think, rather than say the ombudsman is better placed to see the duty of care taking into account public interest, I would put a plural. Because I think what you have in mind, also knowing your research, it's not the classical administration à la française, l'intérêt général. It's that the general interest is a composite interest, and that what you are looking for is the fact that the European Ombudsman, not having to decide that a decision is void, can say, well, maybe there are ways to be more inclusive in getting the different aspects of public interests in the plural. That's probably something which you want to say and could say better in the future.
I won't take too much time. Yes, that is precisely it. And I think in a way, both interventions, I hope, reply to the question of Jacob Soderman. It's something different than just the perspective of the complainant. It's the plurality of the interests that need to be taken into account by the institutions when deciding. And I certainly need to develop this further, and I certainly apologize for my level of abstraction, which has partially to do with the fact that the ideas are not as developed as they probably should be at this point. But my point is that the Ombudsman can go deeper into this balance and into how environment, public health issues, etc., may play out again, not may play out substantively against issues of competitiveness, to use the example that I used before, but to see, okay, public interest, these are the public interests that by law are mandated. The structures clearly favor, the structures, and by structures I mean groups, etc., clearly favor one. So it's legal. It's legal. There's no problem there. But maybe there's a better way of doing it in view of inclusiveness. Just a very brief, I thank you very much for your remarks. But I just one clarification, I did not mean that the court only does this, certainly not. I was trying to focus on that area where after everything else has been checked, then when it comes to these assessments, what is at stake? Thank you. Thank you very much for all the input. It's been very important.
Okay, thank you very much. And on that last word, I'll draw this session to a conclusion, so we can all have some tea or coffee according to our choice. Thank you again very much, Joana, for a most stimulating presentation, and thanks to all those who commented and asked questions.